victims and family members of those killed in the Club Q shooting say they are planning to sue El Paso County. The victims claim that shooting could have been prevented if the sheriff's office triggered the state's red flag law after a 2021 bomb threat incident involving the suspect. News 5's Maggie Bryan is joining us in studio to break down those claims. Maggie.
Yeah, Rob and Diane, 10 victims are suing the county for $20 million in damages. The sheriff's office and the district attorney have argued in the past, however, that even the red flag law would not have prevented the shooting at Club Q. These documents filed last month by several victims of the Club Q shooting outline an intent to sue the county after a gunman opened fire inside the club last November. Some of the victims listed include the sister of Kelly Loving and the mom of Raymond Vance, both shot and killed that night. The victims claim the incident could have been entirely avoided had the El Paso County Sheriff's Office utilized the Colorado red flag law. Otherwise known as extreme risk protection orders, the law allows family members or law enforcement to temporarily restrict someone from being able to own firearms. A temporary order can be granted for 14 days. After that, a court can issue another order for 364 days. The victims claim that the sheriff's office should have used the law in 2021, when the suspect was accused of making a bomb threat inside his mother's home in a Lorson Ranch neighborhood. The sheriff's office and district attorney's office have addressed these allegations in the past, the first time at a news conference just 3 weeks after the shooting at Club Q.
An extreme risk protection order would not have prevented the Club Q shooting.
District Attorney Michael Allen said the suspected shooter was charged with multiple felonies in the 2021 bomb threat incident. He said with those charges came a mandatory protection order that made it illegal for the suspect to own firearms.
Mandatory protection orders automatically go into effect when we file a felony case, which achieve the same effect as a red flag order.
The sheriff's office says that order was set in place by a judge 4 days after the suspect was arrested in 2021. The office says the suspect was legally unable to own a firearm until the case was dismissed over a year later and the order was lifted. It was lifted 4 months before the shooting.
I want to point out that the case was pending for 383 days under those felony charges. That is longer than an extreme risk protection order provides.
Allen also stated that a 364-day extreme risk protection order requires a much higher standard of proof than a temporary order.
It seems unlikely that law enforcement would have been successful in achieving anything other than a temporary extreme risk protection order, which would have lasted for only 14 days from the date of that event.
Former El Paso County Sheriff Bill Elder made it clear when the red flag law was passed that his office would not petition for their own orders unless there were exigent or immediate circumstances that required such order.
We're not going to pursue these on our own, meaning the sheriff's office isn't going to run over and try and get a court order.
I reached out to the sheriff's office and DA's office for comment, but was told they could not comment on active investigations or pending lawsuits. The law firm representing the victims tells me a civil complaint will be filed soon.